Hey everyone. So this audio is the hearing decision that was made for incident report 168910. This was followed by the case summary, the email exchanges for the hearing and the hearing itself. So if you haven't done so, you have to take a look at that, which has already been posted. So for this hearing, I ended up not capturing the video because at this point I thought things would settle down and, this would be a positive outcome, positive decisions would be made. And especially after the case summary. But things didn't go as planned, so I ended up having to readjust later on. But I still ended up capturing this audio on my phone, fortunately. So I do have this over here. There's not a lot of points that I have to add compared to the hearing on this, but there was one point where, I was being lied to blatantly in my face. So I do have to point that out so that, people become aware of that part of this audio. So I'm going to point that out when that occurs. But the rest, there's not much I have to say except for a few points here and there. So you guys can take a look. I'm going to play the audio now.
Hello, how are you?
Hey Marla, good. How about you? How's it going?
Hi. Good, thanks.
My sister, she's right here.
Hello.
Hi, how are you?
I'm good. How are you?
I'm great, thanks. Aishan, can we have your sister's name just for the purposes
Yep.
of,
Her name's Aisha Wasim. She's a student at McMaster, policy analyst, and freelance. So
Freelance journalist.
you can have that down.
How do you spell your first name?
Aisha
Sorry.
and Wasim. Waseem.
Her name's Aisha Wasim. She's a student at McMaster, policy analyst, and freelance. So
Freelance journalist.
you can have that down.
How do you spell your first name?
Aisha.
So, again, I just wanted to thank you for coming today and for being able to, meet with me in person rather via Teams rather than just receiving a letter in the mail or via email, giving us an opportunity to talk about the decision that we've made. So before I get into the decision itself, I will just mention that our student code of conduct. So I have to point out that at this point the case summary was sent out. The student first staff had to look at the case summary and everything, and in that the law, Canadian law was also used to you know justify why this wasn't a threat. This is unsubstantiated allegations of threatening behavior, and the university actually uses the policy, especially the student affairs staff here. They end up using the policy to override that comment or that quote within the case summary. So, it's very interesting because in the policy, this university policy is vague. You have threatening behavior, something classified as something that can be seen as threatening to someone, and then the Canadian law itself is very narrow, so it points out what exactly is threatening behavior. Now, what these guys end up doing is they had leverage. They had space to move around and make arguments however they wanted. So they end up using that policy, the threatening behavior part within the policy, to actually override the law which was quoted in the case summary. So I had to point this out regarding the threatening behavior part that they mentioned. You indicated that you had made that post. You had also indicated that that was not your intention to be threatening to that individual specifically. However, you recognize that some individuals could interpret that as a threat to well-being. So for that reason, I have found that you are responsible for violating Section 6.3 of the code. In terms of outcomes, so what are the sanctions that would be applied because of that violation? Number one is 1 year of probation under the Student Code of Conduct. So I know that this is a point that most students kind of take a deep breath and say, oh my gosh,
It's not academic probation. So it's probation under the non-academic misconduct process. So if you are found responsible for violating the code in the future, in that 1 year period, the outcomes may be more difficult. We say, okay, we've had this conversation, you understood particularly what the Student Code of Conduct is, and you should reasonably have known to not violate the code further. So for a 1 year period, any outcomes, if you're found responsible for another violation, might be more difficult. And then the other outcome, and this for me is the educational piece, is you will be asked to write a 500-word essay on professional communication. So kind of the characteristics and strategies of effective professional communication. Obviously, some online communication has been challenging and difficult for you, as well as we'd like to see aspects of in-person or written communication in there as well. I see that you are reacting to that, so can you tell me about that?
So if you got a chance to see my camera, you guys could see that I wasn't just, my reaction was actually I was laughing at what they were saying with the mic turned off, of course. But it was just so absurd that I started laughing. The decisions that were made. All of this, having to go through all of this, and then have them telling me to write an essay on professional communication. So it was so absurd. I started laughing, and then they obviously saw that, so they were asking me to. I don't know why they wanted me to comment on it or something on my reaction. So I did.
I totally disagree with it. I do not accept these conclusions, and I feel that this is an unjust decision. Implied metaphor does not count as a threat, and if students are taking anything can be taken as a threat. If an apple's falling from a tree, I can be like, oh, the apple's gonna kill me. I can take that as a threat too.
This was a very extreme example, but you guys can see what I'm trying to get at with this. It's more so to say that things can be twisted and turned however they want to be twisted and turned. There's no, I could even argue from that perspective that I'm not real. I'm just a spirit, so I can do whatever
I completely disagree with that, but if that's a decision that's you made, that's perfectly fine.
Right. Perfect. And so, absolutely, you have the right to disagree with this decision. I don't expect in every case that a student will and I will see eye to eye, for sure. But you also have the right to appeal the decision should you feel that is necessary or for something you would like to do. Your appeal process will be outlined in the letter that I'm going to send to you after, but you can do that to Brad Clark, who is the Director of Student Life and Success, and that has to be done within 10 business days of receiving this decision. So after you and I finish our meeting, I'm going to send you the decision letter in email, and you'll have 10 days from that time to appeal. The letter will outline the grounds for which an appeal can be made, and they include new and significant evidence has emerged that wasn't available at the time of the hearing. There's clear evidence of bias in the hearing, or disciplinary procedures were not followed. So we made a procedural error, and the outcome was significant.
The hearing should not have happened in the first place, Marla.
I understand that that's your position, absolutely.
Yep.
And so if you feel that there is an evidence of bias, that's one of the appeal routes for you, for sure. So that is the outcome. The letter would be due by July 1st to me. You would send the 500-word essay, so it's 2 pages.
And what happens if I don't write this? Because I know how to do professional. No student's gonna give you a case summary like I did. I know professional communication pretty well. So if you want me to write that, I want to ask you what happens if I don't write it.
Okay, very good question.
Just look at the condescending tone and the way they talk. It's a very good question. Like I'm a child. It's such a condescending tone. So disrespectful. And it's all done while smiling in your face and pretending to be your savior.
So if you don't write in, if you decide not to engage, then what we would do is we would send you a reminder saying, hey, you failed to submit it by the time frame that was required. You know, in a lot of instances, we will grant an extension, a 1-week extension to that. And what we would do at that point is say that you may have violated the student code of conduct if you fail to submit your outcome at that point, because it would be considered to a violation of 6.1, which is failure to comply with the direction of a university official. So you would have been given.
So I was innocent. I had to come out here and prove my innocence, and then after that, I'm getting unjustly charged with threatening behavior over a metaphor. All right. If that's what we have to do, sure. I'm gonna appeal this decision. This is totally not fair, and we'll take it from there.
Absolutely. Appeal is your right. For sure. If you feel you need to exercise that 100%. Again, I will remind you about the Ombuds office. They are there for you to support it as well through the appeal process, not just the hearing process. So if you want some advice, you want to review some information with them, you can absolutely get in touch with the Ombuds person. I'll put that in the email to you as well.
Okay.
Okay? Awesome. I know it's not the outcome that you were hoping for, and I know it's not an outcome that you can you support. So I know it's probably difficult to hear, but I do appreciate your respectful engagement and you coming today.
So this is the part where they totally end up lying in my face that this is because of the policy. You'll see now. Just listen to what they say, and just listen to what the question that I ask, and then listen to how they try to lie, and then when asked another question, they turn the answer into something else, a totally different answer.
Thanks. I have a question before we end off.
Sure.
So you did tell me twice in the emails that we can't have recordings or transcript for the hearings. So I do want to ask what's the policy or the reasoning for that?
It is not something that is allowed through our policy.
What's the policy then?
Pardon?
What's the policy?
We don't allow recording.
Can you quote me the policy, or find it and quote me, please?
It's not. I don't believe it's written in the policy. It is our practice to not.
It's not. I don't believe it's written.
So you just told me that it's not there in the policy, and now you're telling me it's not in the practice when I asked you to quote it.
So perhaps the policy was the wrong word to use in that particular instance. It is not a part of our practice to.
So if you go to a court hearing, Marla, you're gonna get a transcript. They're not gonna. So you're in courts. They're not gonna ask you to you can't record, but you will get a transcript of the entire hearing itself if you want. So I came to this hearing, and you want me to type my own notes, and that's totally unfair to me. I need a support person every time to get those notes typed.
So it's not a legal proceeding, it's an administrative proceeding.
I understand that, but also another point is that in the last hearing, I was told that, I don't have any witnesses, and luckily I had a witness. What if I didn't have a witness? I'm proving my innocence, and then I'm still getting, I'm getting into problems because I'm not gonna have a witness. That's not fair. But I understand. You made your decision. I'm gonna appeal this, and I appreciate, you highlighting, these points about the ombudsperson and the appeal process as well. So I'll wait your email and then go through that route.
Okay, thank you so much.
Thank you.
So that was the end of the decision. It was, as you can see, it was very absurd decision that was made for a simple metaphoric comment, metaphoric message to someone that was harassing me with his group of friends and mobbing me up. But that took place, and then following this, there was the appeal that was started. A letter of appeal was sent out, and then the appeal hearing and everything. So you can follow that, and yeah, that's about it. Thanks, guys. Thanks for listening.